So we have new developments today in the rape trial that's sending shockwaves throughout a New England prep school. The lead attorney for the 19-year-old defendant wrapping up the defense's cross-examination, asking some very pointed questions of the now 16-year-old accuser.
Would it be fair to say he couldn't know that you were uncomfortable because you were laughing?
No.
That's not fair to say?
That is not fair to say, no.
You're sure about that?
I am very sure about that right now.
Well, things also taking an emotional turn when the attorney asked her why she later told police that she was, quote, cloudy. Listen to this part.
Were you already being cloudy and confused the day before you got together with Owen?
No.
Well, why were you cloudy?
I was raped. I was violated in so many ways. Of course, I was traumatized. I'm sorry.
So upon completing her testimony, the accuser putting out this statement saying, quote, today I no longer feel like a victim. I feel like a survivor. Let's bring in Dan Schorr, former prosecutor, John Lauro, former federal prosecutor and criminal defense attorney. Dan, let me start with you. You used to prosecute sex crimes, right? You also teach a sex crime class now at Fordham. Is this behavior, is it what we sometimes see in cases like this?
Absolutely. Whether or not this particular accuser is telling the truth, it's important to understand that victims of sexual assault very often afterwards feel guilty, they feel scared, they feel confused, and that could lead to a delay in reporting or an inconsistent giving of information immediately after the fact. So just because after this alleged incident, she didn't immediately tell anyone, or she told someone that it wasn't necessarily not consensual, that doesn't mean it wasn't rape. There's other factors we have to look at, and the jury has to look at the totality of the evidence before deciding guilt or innocence.
So, John, let me ask you this, because what we showed in those clips was that she apparently was laughing during, her discussions with this gentleman, and that apparently she also helped him remove some of her clothing. And then afterwards, there were sort of these friendly texts between the two of them. What do you make of that?
I think it's critically important, and that's what the defense was reaching for. They really weren't focused on what happened in reporting. They were focused on what happened in real time. And what we see is that she admitted that she was laughing during the encounter. She helped take off her clothes. They had mutual texts afterwards. She was interviewed 2 days later by a school nurse and never mentioned any rape. So I thought the defense lawyer did an excellent job in bringing those out. It's a very, very difficult cross-examination because you're dealing with an otherwise sympathetic person. You have to be very careful not to be a bully, not to overstep, and the lawyer hit exactly the right tone, and he got great information out.
Do you agree with the fact that was it over-bullying by this lawyer?
I think the defense attorney did what a defense attorney has to do, and that's one reason victims of sexual assault don't want to come forward, because they know they're going to be subject to a rigorous cross-examination. Of course, it's essential that it happens because that's part of the justice system, but still, it's a difficult part of someone who was sexually assaulted to then have to testify in open court and be cross-examined about it. But in our system of justice, you have to have that to protect the rights of the accused.
So would you think that her lawyers will bring on experts then to talk about exactly what you're talking about today, Dan? That sometimes we see this happen, that it's a pattern sometimes with a victim, that they do behave in this way, and yet it doesn't necessarily mean they're not telling the truth?
They may. I've called witnesses like that in domestic violence cases and in sexual assault cases where you want to explain to the jury that just because someone is uncomfortable after in reporting it or delays in telling people exactly what they say happened, that doesn't mean the incident didn't happen, that's actually common. Doesn't mean this person's telling the truth necessarily, but they shouldn't be discounted just because of those
John,
factors.
how do they get to the truth then?
Well, through cross-examination. I mean, the best way to get to the truth is to ask those questions. And those were the tough questions that the defense lawyer asked. You can bring in witnesses that can talk hypothetically about what happens to a hypothetical person in that situation, but jurors want to know, what did this person do in the exact set of circumstances that she's accusing this defendant of doing? And the question is, her conduct is inconsistent with an accusation of rape, and that's what the defense brought out.
Okay, so where do you think it goes from here?
Well, one big question is, does the defendant take the stand? And a lot of times where there's a consent defense, the defense does take the stand, but they'll have to determine whether they have made out reasonable doubt based on the cross-examination. If you see him take the stand, then obviously he'll also be subject to rigorous cross-examination by the prosecutor.
And he's going to take the stand. I believe the defense has already said that. And talk about bullying. Wait until you see that prosecutor cross-examine him.
Well, we will no doubt be covering the case. Gentlemen, thank you so much.